degree domestic assault. As far as sentencing, then what is the state's recommendation?
Thank you, Your Honor. In reviewing the PSI, there's some things of note. Mr. Martinez has a criminal history pretty solid from 2010 to the present. His first adult criminal conviction was also a domestic. He has been on probation or PRS 6 times and he has never successfully completed it. I'd also indicate in reviewing his statement and the victim's statement, voluntary intoxication is not a defense under Nebraska law. I also noted he appears to downplay his own behaviors that day. He does freely admit that he struck her, but there were other indications that he wasn't fully endorsing his actions. I also noticed in the victim's statement the lasting impact not only on her but her child to the trauma that day. His LCMI is a 33. That scores him as a very high risk to supervise and a very high risk to reoffend. His domestic violence matrix is also high risk. I want to quote, possible presence of a heightened, obsessive, and or unrelenting nature of abuse and possessing a high risk to this or other victims. His SAQ is also at a maximum risk for drugs, alcohol, violence, and antisocial behavior. Your Honor, anything less than the substantive incarceration of Department of Corrections is a miscarriage of justice to the community, to this victim. He has had multiple opportunities to address his substance use and his mental health, and instead he continues to terrorize. So I would again ask for no less than 10 or 15 years on the bottom at the Department of Corrections.
Thank you, Ms. France. Ms. Vickers.
Thank you, Your Honor. I would first ask the court to take into account he did take responsibility and admittedly in this matter. I don't believe he was trying to downplay the circumstances, Your Honor, or make an excuse that this occurred only because he was drinking. I think that through the course of this, he was trying, in his words, to explain to the court why he believes the situation got out of hand in this incident. I think he freely admits that he's had a long history of addiction, and unfortunately with addiction, there's a number of possibilities for relapse and so forth, and he really hasn't had any significant formal treatment for that. And so that was what he was trying to explain, that he had been using, he had been drinking on top of it, that things got out of hand. He admits he assaulted her, and he admits that he was wrong, and he showed remorse for that in there, which I think is appropriate. As to the lasting offense, I understand the victim's concerns and the issues with that. As to her statements concerning the minor child, I think there was depots where the child clearly stated in those that he did not hear anything or know what was going on until his mom came into the room, and was not severely impacted at that point. So I would ask the court to consider a term of incarceration. He understands appropriate, or that probation is not warranted in this case, but I also believe that based on the circumstances and the information provided in the PSI, that a maximum sentence is not required.
Thank you.
Oh, yeah, Your Honor, I am really sorry, first, for you guys to have to deal with this, the judge, you, his friends, my lawyer, sorry about my family, because I've been in and out of jail since, I was 18, 19, drugs, all this stuff, just dumb stuff. I find my family, and I want to apologize also to the victims, I'm really sorry, and I don't have to live with this for, forever, because of what I did to her, and it does bug me for how I come hand on her, and I do have remorse for it, I'm deeply sorry for it, and I just want you to know I'm very sorry.
Thank you, Mr. Martinez, I appreciate it. Ms. France, is there any reason why the court should not proceed to sentencing at this time?
No, ma'am.
Ms. Vickers.
No, Your Honor.
All right, thank you. The court court has reviewed the pre-sentence investigation report and the recommendations provided in that report. I have also considered all of the sentencing factors set out in section 29-2260. Having regard for the age, mentality, education, and experience, social and cultural background, past criminal record or lack thereof, motivation for the offense, nature of the offense, and the violence involved. I do find that imprisonment of the defendant is necessary for protection of the public because the risk is substantial that during any period of probation, the defendant would engage in additional criminal conduct, and because a lesser sentence would depreciate the seriousness of the defendant's crime and promote disrespect of the law. I find that there are substantial and compelling reasons for a period of incarceration, which include the criminal history of the defendant, which includes past assaults and domestic violence, the defendant's LSCMI score, as well as the DV domestic violence score and the SAQ score, all indicating a high risk or reoffender or a high risk. Also, the circumstances of this crime were particularly violent and resulted in some very serious injuries to the victim. There are some mitigating factors that have impacted my sentencing decision, which include the defendant's taking responsibility and admitting from the outset that he did lay hands on the victim, as well as the environment in which the defendant was raised. It appears that he's not had a positive influence showing him what a non-criminal life looks like. Given that, I am going to sentence the defendant to a period of incarceration of no less than 10 years, no greater than 15 years. The defendant is given credit for, the PSI had 193 days. There were some additional days, I believe the jail roster shows 322. Ms. France, I guess Ms. Spiker, is there any objection to applying 193 days credit?
No, that's correct, Your Honor. The other ones were used for our probation.
And that's what I thought so as well, Ms. France, does that sound correct?
That is correct. They were used for other cases, and the parties had agreed that this sentence would be consecutive.
Okay, so the defendant will be given credit for 193 days served. Costs in this matter will be deemed uncollectible due to the length of incarceration. While there was some damages to the victim, I received no information regarding restitution, so no restitution will be ordered at this time. Am I missing anything, Ms. France?
No, ma'am.
Ms. Spiker?
No, Your Honor.
Okay. That concludes this matter. Thank you both.